Hello, everybody. Welcome to today's webinar, Building Effective Sexual Harassment Prevention Policies and Training. My name is Travis Boisvenu, the Marketing Manager at iSight, and I'll be your host today. I'm joined by Philip Miles, who is an employment attorney specializing in labor and employment law and general civil litigation. Before we get into the webinar, and while I have your attention, and before I hand the controls over to Philip, I'm going to show you a quick video about iSight software. iSight Case Management is a powerful software that helps streamline your investigations and helps you detect and prevent HR incidents. So you should see a 30-second ad right now on iSight software. Just a few administrative notes. As we're going through the webinar today, feel free to use the question box in the webinar panel to ask questions. Philip will try to address as many as possible with the last 10 minutes of our time today. We've got 3 poll questions today, so watch out for those as well, and you can fill those out. We usually leave about 30 seconds to 60 seconds for people to fill in those polls. This webinar is being recorded and will be added to our webinar library along with a copy of the slides. We will email out the link to the recording and your certificates of attendance in the middle of next week. So as I mentioned, our presenter today is Philip Miles. Philip is a Pennsylvania attorney focused on labor and employment law and general civil litigation. A graduate of George Mason University School of Law, Philip returned to State College where he currently practices. He also teaches graduate and undergraduate labor and employment law for Penn State's School of Labor and Employment Relations, and he writes an employment law blog at lawfacespace.com. That's it from me, so I'm going to hand the controls over to you, Philip, and you should have them any second to take it away from here.
Okay, thank you, Travis. It's going to be right now, and so you should now see my slideshow. Good afternoon, everybody. Thank you for joining us today. I'm happy to be here. My name is Phil Miles. As Travis said, I'm an attorney in State College, Pennsylvania. I focus mostly on labor and employment law. And so I do a fair mix of both compliance issues, things like helping employers with employee handbooks and training and policies. And also, say probably about 3/4 of my time is practicing litigation and litigating employment law cases. So today we're really going to be breaking this down into 2 different topics. One is building a strong and effective sexual harassment prevention policy. And the second topic is addressing an effective training program. So to start with, why does your sexual harassment policy matter? There are a few reasons it matters. Some are practical, some are technical legal reasons. So for example, there are actually defenses that are available to sexual harassment lawsuits and claims that will be based in part on your sexual harassment policy. So if you're an employer and you get sued for sexual harassment, in certain cases, courts will actually look to see whether you have a sexual harassment policy and whether it's an effective policy. We'll get into this in a little bit more detail later, but at a high level, for example, an employee alleges harassment by a coworker or a third party, like a customer or a vendor, that's going to be addressed under a negligence standard. And a court's going to look at whether, as an employer, you took reasonable steps to prevent and correct harassment. And one of the things they're going to look for is whether you had a sexual harassment policy. Similarly, in cases of hostile work environment where the harasser is a supervisor, there's an affirmative defense available to employers. And one of the elements of that, there are several elements, but one of the elements is, did the employer take reasonable steps to prevent harassment? And fundamentally, that's going to look at whether the employer had a policy in place. There are also practical reasons, though. So a strong policy will signal to employees that harassment is taken seriously and not tolerated in the workplace. And so it's an important signal from the top that sexual harassment is something that's important to the employer and that it is not allowed. And then finally, it provides a roadmap for employees who may be experiencing harassment or who maybe have witnessed harassment to report a problem. So Travis, if you could please throw up the first poll question, which is basically asking the audience, when was the last time you reviewed your sexual harassment policy? Now, nobody is going to be called out individually for their response, so you can go ahead and be honest with this. I'm just trying to get an idea for how often you're looking at your policy and making changes. So I see that the poll is now open. While you're selecting your responses, I'm going to go to the next slide and start discussing.
Oh, actually, sorry, Philip, I should say while the poll's open, we can't see the slides. So if we just leave a few more seconds for people to fill that in, maybe it looks like a big amount of attendees have filled it in. So let's close that poll and look at the results, shall we?
Okay, sounds good.
And here's the results. So if you can see that, we have 56% said less than 1 year, 11% said we don't have a sexual harassment policy, 24% said 1 to 3 years ago, 8% said 3 to 5 years ago, and 2% said more than 5 years ago.
Okay, thank you, Travis. I appreciate that. And I cannot see the results, so it's very helpful to me for you to read them out. And so that's great that 56% have reviewed their policy in less than a year. There's no magic number for this, so I don't want you to think that there's a right number. I usually recommend that employers have their handbooks reviewed comprehensively by legal counsel, whether that's inside or outside counsel, every 2 years, maybe every 3 years. One thing I will strongly emphasize, though, is if you don't have a sexual harassment policy, even if you don't have an employee handbook at all, if you adopt one policy, I would recommend that it be a sexual harassment policy for the reasons I explained on the first slide. There are defenses that are available to you in a sexual harassment case that will look at your policy. And that's fairly unusual. There are not a lot of circumstances in which your handbook is something that's going to be directly reviewed by a court. So when I say you should have a sexual harassment policy, what are the elements that I recommend you include in that policy? These bullet points summarize those things. We're going to dig down into each of these in a little bit more detail, but to start at the high level, the harassment policy should include the protected characteristics. So today we're focusing on sexual harassment, but I should note that hostile work environment claims may arise from any of the other protected characteristics as well. So you may encounter race-based hostile work environment claims or disability harassment. So, to the extent you have a harassment policy, it should be clear that it covers all the protected characteristics, not just sex, and it should identify what those protected characteristics are. It should include a definition of prohibited harassment. So this will be an explanation of when we say no harassment, harassment's not tolerated here. There needs to be some kind of explanation to employees about what that means. A good policy will include complaint procedures. In other words, if somebody experiences harassment or somebody witnesses harassment, what do they do about it? An employee in that situation will likely turn to their handbook to figure out what to do about it. So you should have clear instructions in there about how to handle a complaint. Acknowledgement forms. If you have a handbook, you want to have sort of a receipt, something that proves that you not only have a handbook, but every employee has received it. There should be an outline of disciplinary consequences. In other words, don't just say that harassment is not allowed. Explain that essentially bad things will happen, bad employment outcomes will happen to people who violate the policy. And then finally, along the way, you may notice I dropped subtle hints about things I think are important. And by subtle here, I mean bold, underlined, italicized, and with an exclamation point, an anti-retaliation policy. This is a piece that I find is often missing from handbooks, and I think it's a critical piece. You should have a policy that makes clear that retaliating against any employee for reporting harassment or for participating in an investigation or really opposing discrimination or harassment in any way, those employees cannot be retaliated against. Retaliation is not allowed. So we're just going to break down each of these portions of the policy. First is to list all the protected characteristics. There are a lot. So the big ones are Title VII protects five characteristics: sex, race, color, religion, and national origin. You have the Americans with Disabilities Act that prohibits disability discrimination. You have the ADEA, the Age Discrimination in Employment Act, that protects employees from discrimination on the basis of age, but it only covers employees over the age of 40. You have USERRA, that protects military or veteran status. The newest federal laws, the 2008 signed by George W. Bush, is the Genetic Information Non-Discrimination Act. That prohibits discrimination on the basis of genetic information. Which is defined pretty broadly to include things like family medical history. An important note here is I practice in Pennsylvania. I think we have participants here today from all over the United States. And so you should be aware of the different state laws that apply to your employees. Those state laws will often include different protected characteristics from the federal protected characteristics. So, for example, there's a news story a few years ago about a server at the restaurant Hooters, and she filed a discrimination lawsuit alleging that she was discriminated against on the basis of her weight. She had gained weight while she was working there and claims that she was fired due to that weight gain. And she worked in Michigan. And as it turns out, Michigan actually lists, or at least did at the time, weight as a protected characteristic. That's something that's not listed in the federal protected characteristics. Does anybody want to guess what jurisdiction prohibits political affiliation discrimination? Perhaps ironically, DC. Washington, DC has a human rights law that prohibits discrimination on the employment discrimination on the basis of political affiliation. So just make sure that when you're listing your protected characteristics, you include some of those characteristics that fall under state law. And one tip I have when drafting your handbooks is list the protected characteristics in one place, define those as protected characteristics, and then throughout the rest of your handbook, refer to the protected characteristics. I review a lot of handbooks, and some employers include this list of protected characteristics in all these different places throughout the handbook, And then sometimes the lists are inconsistent, or they update one area and forget to update the other area. If you just have one definition of protected characteristics, you only have to make sure you're maintaining that one list. So let's talk about, quote, sex. When you signed up for this webinar, you probably were not expecting a reference to 90s rap group Salt and Peppa, but here we are. Sex covers women, obviously, but it also covers men. So you should be aware that men can and do file sexual harassment claims. Now they do account for the minority of sexual harassment claims, but they're not at all uncommon. So you need to understand that men may file claims. Also, same-sex claims are cognizable. So, for example, a man could be sexually harassed by a woman or could be sexually harassed by another man. A court's not going to really treat that any differently. Gender stereotyping is a form of sex discrimination. So I actually have an example of that in the next slide, and we'll explain it in a little greater detail. And then you probably heard about this, but last year the Supreme Court in the case of Bostick v. Clayton County held that Title VII's prohibition of sex discrimination includes sexual orientation and gender identity. So if an employee is being harassed or discriminated against based on their sexual orientation or gender identity, that will be a potential claim under Title VII. So sometimes the question arises, well, Title VII just says, quote, sex. So should my policy just say sex, and we understand that to include sexual orientation and gender identity, or should I add those to my list of protected characteristics? I recommend adding them for the simple reason that I think the average reader or your average employee will not see the word sex and interpret that to mean sexual orientation and gender identity. So part of the reason you have a policy is to explain the expectations to your employees. So it's important that they understand it. And so, they may not have read the 50-page or however long it was Supreme Court opinion to explain why those things are covered by sex. So I think it helps to just tell them in your handbook, hey, look, we prohibit discrimination on sexual orientation and gender identity also. So I mentioned that gender stereotyping is prohibited. This is an excerpt from a case in the Third Circuit Court of Appeals. It's a federal appellate court with jurisdiction over Pennsylvania, New Jersey, and Delaware. But this same concept applies nationwide. It's not jurisdiction specific. In this particular case, there was a gay employee, and he, quote, had a high voice and walks in an effeminate manner, did not curse, and was very well groomed. I think this next bit gives you an idea of the type of workplace he worked in. He was an outcast because he, quote, filed his nails instead of ripping them off with a utility knife. And he crossed his legs and had a tendency to shake his foot the way a woman would sit. He also discussed things like art, music, interior design. He pushed the buttons on this piece of machinery he used called a nail encoder with pizzazz. So his coworkers mocked him, called him princess, rosebud, anti-gay slurs. They placed man-seeking man newspaper ads. Now, under Bostick, this sounds like it would probably be sexual orientation discrimination. But even before Bostick, the courts recognized that this was a form of sex discrimination called gender stereotyping, essentially applying gender stereotypes to someone and discriminating against them or harassing them for not conforming with those stereotypes. So, in this case, you get the impression that it's the kind of workplace where the men consider themselves manly men, and when this young man was not considered, quote, man enough because he filed his nails and sat with his legs crossed, he was harassed. that's a form of sex discrimination. You should note that gender stereotyping is prohibited, and you should understand that's a potential harassment claim. This form of discrimination was first recognized by the Supreme Court of the United States in a case involving a female employee who was up for partner at Price Waterhouse, who was allegedly denied partnership because she wore pantsuits, had short hair, cursed too much, and they recommended that she essentially be a little more feminine to get partnership. Well, there again, it's essentially applying stereotypes of how people of a certain sex are supposed to behave, and that type of discrimination is not allowed. So we talked about the protected characteristics. I said that another part of your policy should be to define the prohibited conduct. So here you're going to want to use a mix of legal definitions and practical definitions. I think it's helpful to use the terms of art that a court will recognize. So if you're ever in litigation, a court will be able to spot, hey, I recognize that. That's the exact language we use in analyzing these types of claims. But I also think it's just as important to use plain English that your employees will understand. At a high level, it's important to note that harassment on the basis of any protected characteristic, not just sex, is prohibited. I see a lot of policies that have a lot of handbooks that have a sexual harassment policy, and they fail to note harassment based on the other protected characteristics. So I would have a policy that broadly addresses all protected characteristics. And then specifically prohibits the two main types of harassment that are recognized as legal claims. One is quid pro quo harassment, and one is a hostile work environment harassment claim. So quid pro quo translates roughly to this or that. It's the idea of employers demanding sexual favors from employees and either having negative consequences or denying those advances or rejecting those advances, or offering favors or positive outcomes for employees who submit to those sexual advances. In other words, it's the supervisor who will only promote somebody if they sleep with him, or threatening to demote somebody if they don't sleep with him. That's considered quid pro quo harassment. And we'll get into the details of this a little bit later, but generally, it will involve some kind of tangible employment action. Something will actually happen to the employee's employment status. The second type of claim is a hostile work environment claim. Here I recommend using the textbook definition. And so, you can see that on the slide: unwelcome harassment on the basis of a protected characteristic that is sufficiently severe or pervasive to alter the working conditions of an employee and create a hostile work environment. That's kind of a mouthful. And so, again, this is the idea that I recommend including the textbook definition, the legal definition. But I don't think that's sufficient. I think you want more than that. You want to also include examples so that employees will understand better, right? A severe or pervasive hostile work environment may not mean anything to the average employee who reads that, but they will understand things like the bullet points down below: requests for sexual favors, unwelcome sexual advances, obscene or pornographic remarks, jokes, images, videos, unwelcome touching, other conduct of a sexual nature, slurs, derogatory remarks, stereotypes. Those types of concrete examples will help employees to understand what is a hostile work environment discrimination claim. It gives them something that they can understand better than the technical textbook definition in the top half of this slide. So one of the most important parts of the policy is the complaint procedure. Employees who experience harassment or who witness harassment will wonder what it is they should do. And when they wonder what they should do, the first place they will go to look is in the employee handbook. And so the first thing I would note in that first bullet point, here's another one of my subtle hints. Employees who feel that they have been harassed or who witness harassment should report. I think it's important to emphasize that even if you're not the one experiencing harassment, if you witness harassment, you should report it. There's probably some difference of opinion here as to whether that should be a should report or must report. I would say I often recommend that employers include must report. The one danger of that is suppose you find out that an employee was sexually harassed and they did not report it. Well, what are you going to do now? Your handbook says they must report. Are you going to fire somebody because they were sexually harassed and didn't report it to you? The optics of that would not be great. And so a lot of employers use the more permissive or suggestive language of they should report, but you may want to consider must report. One of the most important parts about having a complaint procedure is identifying who they should report to. So this is absolutely crucial. There must be multiple avenues of reporting. So if possible, I usually recommend that employees have the opportunity to report harassment to their supervisor or to human resources. A lot of this is going to vary based on the structure of your company or the size of your company. I mean, Title VII applies to employers as small as 15 employees. A 15-employee firm may not have a dedicated human resources person, let alone a human resources department. But you should always have two people. And I recommend that one of them should be the supervisor. The reason for that is that employees sometimes want to make a report to someone who they know well, who they feel comfortable with. Supervisors are often seen as mentors, people who answer questions or address concerns of their employees. So I think supervisor is the logical person to direct people to report sexual harassment. Now, there is, of course, one obvious problem with listing the supervisor, which is the harassment may involve the supervisor. And in a lot of harassment cases, the harasser is the supervisor. And that's exactly why you need multiple avenues of reporting. The last thing you want is for somebody to be experiencing harassment and for them to have the only complaint mechanism be that they report the harassment to the person harassing them. That's why it's so important to have multiple avenues. There are some advantages to having it be the human resources person. The employee may want to go to somebody who's a little detached from the situation, who's not with those employees day in, day out. And so that's why I recommend supervisor, somebody who's really close to the employee, who they're very comfortable with, and then also a second avenue, which I recommend is human resources, because they're ordinarily a little bit detached, and some employees may be looking to go that route, or the harasser could be the supervisor. There are other possibilities. If it's a nonprofit, perhaps somebody on the board of directors, if it's a partnership, and there are a handful of owners, perhaps one of the owners. Sometimes when I'm talking to employers and they take this concept of multiple avenues of reporting too far, and they say, well, if we want to give the employee opportunities to complain in a way that they feel comfortable, why don't we just say they can complain to anyone? That way they can find somebody they really feel comfortable with and we're sure they're going to make the report. Well, the problem with that is they need to be directed to somebody who understands the importance of responding to a sexual harassment complaint, somebody who knows what to do when they get a sexual harassment complaint, and somebody with the authority to take action should they get a sexual harassment complaint. So if they just go to their coworker who doesn't have any power or idea of how to respond to a sexual harassment complaint, nothing's going to get done, potentially. It's important that you direct complaints to somebody who understands what to do and has the authority to take some kind of action. That complaint procedure policy should include a couple of other components. There should be some assurance that the employer will conduct an investigation. I usually keep this vague because the level of investigation required and the process for actually investigating is going to vary a lot depending on the allegation. But you do want to assure the employee that it will be looked into. It should note that employees should report harassment by third parties. That's not always obvious to employees that, or even employers, that employers can be liable for harassment by third parties, by customers, by vendors, by contractors. If as an employer you find out that one of those third parties is harassing one of your employees, you actually have an obligation to respond in a non-negligent manner, to take reasonable steps to stop that harassment. The policy should note that if it's appropriate, the employer will take appropriate corrective action. Again, I would leave this fairly vague, but just note that if after investigation the allegations are founded, appropriate corrective action will be taken. Should note that all employees are required to comply with investigations. And then finally, an explanation of confidentiality. I'm going to go into a little more detail on confidentiality. I sometimes see handbooks that say things like, we will maintain confidentiality, or we'll keep everything absolutely confidential. You absolutely cannot do that. There are several circumstances in which, as an employer, you just cannot maintain confidentiality. So, you may want to say something like, we'll keep complaint and investigation as confidential as possible, but may be required to disclose information to conduct an investigation and as required by law. So, for example, when you get a complaint of harassment as an employer, you have an obligation to promptly correct and stop ongoing harassment. And that may require talking to people and conducting an investigation and separating the harasser from the harassee. And you can try to maintain confidentiality as much as possible, but to some extent you're going to have to do something, right? Similarly, if somebody files an EEOC charge, the employer has an obligation to comply with the EEOC's investigation. And then, so you can't maintain confidentiality. You can't say, oh, sorry, EEOC, we'd love to help you out and issue a position statement about what happened here, but we promise the employee confidentiality. That's not going to fly. You're going to have to respond to the EEOC. And then finally, if you end up in court and you have to go to litigation, the discovery process does not include an exception for where you promise the employee in your handbook you're going to keep things confidential. You're going to have to hand those things like complaints over in the discovery process. So there should be a note that you will try to keep things confidential, but we'll also make clear that there are circumstances where you may have to disclose that information. Finally, there's a little note there. Make clear that nothing in the confidentiality expectations is intended to prohibit employees from discussing terms and conditions of employment. The National Labor Relations Act allows employees to engage in protected concerted activity So employees are allowed to discuss with one another to address the terms and conditions of their employment. And so you should make clear that you're not infringing on that right with your confidentiality provisions, and that employees may report to government agencies, and the confidentiality provision does not bar them from doing that. Travis, if you could put poll 2 up. Yeah, this is going to be a question about the state of your harassment policy. And it's going to look a little bit more at distribution and how you track distribution.
Okay, so the poll is up now. Just for reference, this was the poll that had answers that had to be abbreviated. One of them simply says, a copy is distributed to employees who sign a form. So I thought maybe you might want to expand on what exactly that form is.
Sure, by who sign a form, I just mean an acknowledgement form. So employers will often have just one page that says, I, employee, have received the employee handbook and acknowledge receipt of it, and they sign their name at the bottom.
Okay, so it looks like our poll voting is slowing down a little bit. I'll just give another couple seconds for people to weigh in before I close that poll. Then I'll read the results to you again.
Okay.
All right, so our attendees should be able to see the results of those polls. Which of the following best describes your practice with regard to your sexual harassment policy? 14% of people said we don't have one. 63% said there's a copy distributed to employees who sign a form. 15% said there's one copy distributed to every employee, no form required. And 8% said there's one available for review, but it's not distributed to every employee.
Okay, great, thank you. One practice I would encourage you to adopt is to distribute the handbook to your employees, in particular the sexual harassment policy, and to maintain acknowledgement forms. An acknowledgement form is basically, like I said before, just a receipt to show that the employee got the handbook. I know some employers, they'll have just a single copy of the handbook, and it's in like the manager's office, and employees can go read it if they want. And that makes it difficult for employees to really have access to the handbook. They should get their own copy. It doesn't necessarily have to be a hard copy. You can distribute it electronically. But there should be some mechanism to record the fact that they received it, even if it's just an email back, or an email receipt saying that they received the email, or an email back saying I received, acknowledging that they got a copy of the handbook. This will help if you ever end up in court, or even things like an unemployment compensation hearing. Sometimes you terminate an employee for violating a rule in your handbook, and one of the things you're going to be asked to show by the unemployment compensation referee is that they were fired for a rule that they knew about. Well, nothing's easier than to establish that they knew about a rule than saying, hey, look, they got a handbook, here's the receipt. They signed it, said they got the rules. So that's a practice that I encourage you to adopt. Disciplinary consequences is another component of the policy. Make clear that the ultimate disciplinary action, termination, is on the table for people who violate the harassment policy, but also leave room for discretion. Because when we talk about harassment and hostile work environment claims, there's a wide range of conduct that we may be talking about. You may have somebody who reports that an employee told some sexually inappropriate jokes. Are you going to terminate an employee because they told a joke or two that was inappropriate? You may, but perhaps you feel that sanction's too severe, and so whatever it is, a warning letter, a suspension will be, or even just a conversation, will be sufficient. So, I think you want to leave yourself the discretion. You want to convey that it's taken seriously and that people face potentially termination for violating the harassment policy, but while leaving yourself some room and discretion for lesser offenses. And then the final component of an effective policy I recommend is an anti-retaliation policy. All of the discrimination statutes prohibit retaliation, so your policy should too. Should include an express statement that the employer will not retaliate against any employee who reports in good faith unlawful harassment, discrimination, or retaliation, or any employee who participates in an investigation or proceeding or hearing by the government or a court. One thing that I encourage is to not only have an anti-retaliation policy, but when you do get a report of harassment, to give a copy of this policy to the employee and to anybody you talk to as part of the investigation. So that if later you face a retaliation claim, you can say, look, we took steps to prevent retaliation. We went so far as to not only have an anti-retaliation policy, but to remind everyone about it while we conducted our investigation. So I would include that in your handbook. I'm going to switch gears here and go on to the topic of training. I have a somewhat sarcastic top secret disclosure there. You will no doubt be shocked to learn that sometimes employees get the handbook, but they don't actually read it. So you have this great sexual harassment policy. It covers all the things that I just went over, but employee gets it. It's buried on page 35. The employee doesn't even get to page 1. They just throw the handbook in their desk and never look at it again. Well, that's one of the reasons I think training is important. It's an opportunity to highlight sexual harassment and call employees' attention to it. It's also important that supervisory employees know how to respond. So it's particularly important to train your supervisory employees that they need to conduct an investigation and take disciplinary action and take reasonable steps to stop harassment if it arises. Training also sets the tone and influences culture. In other words, employees will see that the employer views this as something important enough to hold a training session on. And then finally, I mentioned earlier that there were defenses to certain harassment claims, and training will also, once again, as a litigator, I can tell you I would love to be able to walk into court and say, look, they've got this great handbook, they give it to everyone, everybody received it, they signed an acknowledgement form, there's training, they trained everyone, they trained their supervisors in how to respond to this. If I'm trying to make out some of those defenses we talked about earlier, those are the types of things I'd really love to see. Travis, let's go ahead and do the third and final poll question that relates to training programs.
Sure thing. So that poll question is up. Attendees, you should be able to see that. It says, which of the following best describes your training program for sexual harassment?
And so what this is really getting at is whether you have a training program and how often you conduct that training.
Okay, so just a few more seconds here for people to vote. You guys can get those in. All right, I'll just close it off here and we can read the results. So attendees, you should be able to see this. Which of the following best describes your training program for sexual harassment? 21% said we don't have a training program. 57% said we have annual training. 11% say we have training regularly, but less than once per year. and 12% say we only do training during onboarding.
Okay, great. That's helpful and good to know. We'll get into how often I recommend training here in a second. But some considerations to think about. What does your state require? A lot of state laws require training. Consider when and for how long to have training. Training materials for all employees, what to cover with all of your employees, what to cover with just specifically your supervisors, what kind of documentation to maintain, and then feedback. You want to collect feedback from employees. I practice in Pennsylvania, so in Pennsylvania we have no requirements whatsoever. Employers are not required to provide training to their employees on sexual harassment, but that doesn't mean that employers here don't have sexual harassment training. A lot of them still do. And I still encourage it for the reasons that I noted on the first slide. It helps with some defenses you want to raise in harassment claims. It helps set a tone and culture. And I like to believe that it's helpful in actually preventing sexual harassment. But a lot of you probably are in states that do require sexual harassment training. And that's going to vary from state to state. So I can't do a 50-state survey in the time we've got here. But things you want to look into are which employers are covered, which employees are covered. Some states distinguish between supervisory employees versus all employees. How often to have the training, how long the training must be, the methods. For example, Connecticut requires a classroom-like setting, and participants must be able to ask questions and receive answers. Is there specific content required? What are the penalties if you don't comply? And some states require certain documentation, usually like attendance records. So that's something you should look at on a state-by-state basis or with your counsel. So I generally recommend that sexual harassment training be part of onboarding and then renewed. So, I think 1 hour every other year for all employees is sufficient. Supervisory employees, 2 hours every other year. I often include the supervisory employees with all employees for 1 hour, and then just have a separate extra hour for supervisory employees that goes into a little bit more detail. Again, this comes with the caveat that look at what your state says. Obviously, if your state requires annual training, don't listen to me telling you that I think every other year is sufficient. Follow the state law. Training content, identify the protected characteristics, define sexual harassment with examples, cover anti-retaliation. These things should sound familiar because all these things are things we just talked about in the creating a good policy. So, part of the training will just be walking through the policy and explaining some of the things we just went over in the first part of this presentation with your employees. I would go into more detail than the policy, cover the elements of a claim. So for example, for a hostile work environment claim, it has to be based on a protected characteristic. There has to be a tangible employment action, which is defined on another slide, you'll see in 1 second, or suffered harassment that was severe or pervasive. We'll go into the definition of that here in just 1 second. The harassment has to have been offensive and unwelcome. And then the last bullet point, just note for the all employee session, I think it's sufficient to just note that there has to be a basis for attributing liability to the employer. And the employer, in some circumstances, will not be liable if it doesn't know about the harassment and is not afforded an opportunity to take steps to address it and correct it. And to emphasize to employees the importance of reporting it so that you can do something about it. I think that's going to be sufficient ordinarily for the all employee training. So for the first element of the claim, based on a protected characteristic, just emphasize that general harassment. I use the example of making fun of a Yankees fan, right? Yankees fans are not protected, are not a protected characteristic, not even in New York. So, while making fun of them may not be nice, it's not going to be a harassment lawsuit. Now, it's not to say that other laws may not apply. If you punch somebody for being a Yankees fan, that might not be a hostile work environment claim. That's still going to be assault, right? So don't do that. Here's the definition of a tangible employment action: basically hiring, firing, failure to promote, reassignment if it has significantly different responsibilities, change in benefits. Explain that a hostile work environment requires either severe harassment or pervasive. It either happens a lot or the harassment's severe. It's an either or. Offensive and unwelcome. Explain that there's an objective and a subjective standard. Is this something that would be offensive to a reasonable person? For example, somebody says, "I like your haircut." An individual employee may genuinely be offended by that. Why are you objectifying me like that? How dare you mention my hair? But probably a reasonable person would not view that as sexual harassment. We have a few minutes left. I do want to just touch on this basis for attributing liability to the employer. For your supervisory employees, you're going to want to explain that your company is going to be liable for harassment by top officials or supervisors. But if it's a hostile work environment claim by a supervisor or a hostile work environment claim involving a coworker who's not a supervisor or a third party, you have a chance to defeat liability by proving that you've taken reasonable steps to prevent and correct promptly any harassment. So I'm just going to go quickly to that affirmative action definition. For supervisors, your company can avoid liability if it's taken steps to prevent and correct promptly any harassment, and the employee has unreasonably failed to take advantage of any preventive or corrective opportunities. So here's why it's important to have a policy. You need to have corrective opportunities that include reporting avenues in order for an employee to have unreasonably failed to take advantage of them. It's also going to help show that as an employer, you took reasonable steps to prevent harassment in the first place. And then for non-supervisors and third parties, once you know or should have known about harassment, as an employer, you have to show that you took appropriate action or reasonable action to stop the harassment. So explain to your supervisory employees the importance of taking that prompt and appropriate action. A couple of specific things to walk through on this slide. We're running a little low on time, so I'm just going to direct you to that slide to point to a couple of things. I usually include a warning about electronic communications. Let them know, like, hey, look, just because you're on social media or a messaging app, rules still apply there. The tone in the all employees training should absolutely be one of encouraging reporting. The employer takes harassment seriously. Harassment's not tolerated. Reporting is welcome, and reporting is safe because you have an anti-retaliation policy. Consequences, you're going to have to tailor the consequences a little bit to the audience. For supervisors, I think you're going to want to emphasize a little bit more, like, hey, this is going to create liability for our company. we don't want that. I think they'll appreciate that a little more than probably all employees. For all employees, I think you want to emphasize that it creates a bad environment for everyone. Nobody wants to work somewhere where people engage in harassment or are the victims of harassment. It's extraordinarily harmful to the victims. The company will lose employees who quit to escape harassment. Potentially bad publicity. You probably seen in the news a software company is just getting hammered over this lawsuit that was filed, alleging a hostile work environment, a fraternity-like atmosphere. And there's a walkout. They were trending on Twitter, so you want to avoid that. For supervisors, there are some things you want to emphasize. Some state laws impose personal liability. Certainly, you want to direct that to the supervisor's attention. Nothing will get them to comply more with the law faster than explaining to them that they face potentially personal liability. Cover the defenses that we talked about in the previous slides. Emphasize non-retaliation and the importance of providing anti-retaliation when appropriate. Finally, the documentation. You want to track attendance. So it's great to have training, but what's even better is to be able to show who was there so that if you have to go to litigation, you can say, hey, that person sat in this training. And whether it's the plaintiff or one of your supervisors who's being accused of harassment, it's helpful to be able to show that they received the training. They had an opportunity to ask questions. They understood their obligations to comply with the policies. So Travis, I'm going to cut it off there. I know you mentioned that there may be questions. Are there any questions?
Yeah, so I've assigned a few questions to you. You should be able to see them if you open your questions layer of GoToWebinar. If not, I can read them out to you, whichever you prefer.
Okay.
Can you see them there?
I can, yeah.
Okay.
One is, how do you define employer? So this is going to vary depending on statutes. The federal statutes define employers, covered employers, based on the number of employees. So for example, Title VII requires at least 15 employees. The ADEA, I believe, requires at least 20. The one caveat I would say is that be careful of the state laws. In Pennsylvania, Pennsylvania has a state law that covers discrimination against basically the same groups of people as federal law, but it covers employers with at least 4 employees. And so, check your state law. The covered employers will be based mostly on the size. And it's not necessarily clear to me generally, how do you decide if somebody's an employee and you're the employer? That can get complicated. Of course, we'll generally look at whether somebody performs work in exchange for money is going to be sort of the first component. And then to the extent that work is controlled by the would-be employer, do they control what that person's work is usually what they're going to look at. There's a question about how do you state broadly for multi-state or international. So for multi-state, what I usually do is have state supplements. So I have a broad policy that covers, for example, all the protected characteristics under federal laws. And then for employees in, say, I use the example of Michigan. There will be a one-pager that they'll sign an acknowledgement form for, saying, in addition to the protected characteristics, you understand that weight is a protected characteristic under Michigan law, and the harassment policy applies with equal force to weight. So that's usually how I handle that issue. The next question is, employees members sign for receipt of code of conduct, which incorporates by reference sexual misconduct and anti-harassment policies. Is that enough, or do you still recommend separate acknowledgement for sexual harassment policy? that's probably enough. Would I prefer? I mean, I would prefer that they sign their name next to, right next to the sexual harassment policy, so that if I have to go into court and put it up as an exhibit, I can put the policy up with their name right on it. But that said, incorporating it by reference to a code of conduct they sign is going to be sufficient to show, like, hey, look, you acknowledge that you got this code of conduct that told you about a harassment policy, and that you could access that policy. So, that's probably good enough, but if you can, I would probably recommend getting it on the harassment policy. My employer has several dozens of administrative policies that may have legal implications if violated, and we do include these policies in our handbook. The handbook is provided to the employees during onboarding, and we do have them sign an acknowledgement form. However, I don't believe the employees are given time to thoroughly read through the policies and instead are thrown into their jobs. Are we creating a risk to the company by doing this? I think that's actually probably the standard practice, right? On day one, you get handed a 100-page handbook and an acknowledgement form saying sign here. If they sign the acknowledgement form should say that they received a copy of the handbook. So as long as I think that the important part here is that you're actually providing them with a copy of the handbook. I don't think you need to actually babysit them and look over their shoulder while they read it line by line. So long as they sign an acknowledgement form that they actually got a copy and that it's theirs to keep, to read, whether it's electronically or printed out for them, I think that's sufficient to show that you provided the policies to them. I don't think you're placing yourself at risk by not literally ensuring that they sit there and read it. And I think that is all of the questions I'm seeing, at least. Are there any more, Travis?
There was, I think we've gone a few minutes over, but I'll give you one more. There was a question about working from home. Let's see here. Yeah, it just said policy guidance on work from home situation. I don't know if you have any recommendations there.
So I guess it's not clear if that relates specifically to harassment. I mean, if you're working outside of the office, you may be subject to harassment by third parties. So I mean, I would just emphasize that even if you're working from home or working in another environment, if you're facing harassment, talk to the employer, and as an employer, we want you to report that to us to see if we can do anything about that. In recognition of the fact that as an employer, your obligation is to take reasonable steps to correct the harassment. And if you're talking about somebody who's not in the office, there's substantially less control. So what's reasonable to do for that outside environment it is going to be different from what's reasonable to do in a closed workplace environment where the employer has a lot of control.
Okay, and that's it for our questions. So I just want to say thanks to Philip and thanks to the audience for submitting so many great questions. If we didn't get to your question today, or if you have something you'd like to ask, feel free to connect with Philip at the address on the slide on your screen. And also be sure to check out his blog at lofficespace.com, which you can also see on your screen right now. If you missed any of the presentation, or if you just want to review the material, you can watch the recorded webinar, which will be posted on our website in a few days. And don't forget to keep checking out our website, eyesight.com, for upcoming free webinars and other resources, or to learn how Eyesight software can help you streamline investigations and prevent HR incidents at your organization. Just want to say thanks again to Philip, and thanks for everybody for attending.
Thank you so much for having me, Travis.